Okay, so PowerPoint. Okay. So what we're going to talk about today is compliance for brand owners, and this includes the compliance required by your contract brewer, co-packer, your out-of-state manufacturer, if your manufacturer is out of state rather than from California. And well, oh, and I went. There we go. Okay, so this is my contact information if you need to get in touch with me after this presentation for any information. Happy to help out. My legal disclaimer that none of this is official legal advice. If you have a specific legal situation, you should consult a licensed attorney with the specific facts of your situation. So there's my lawyer-esque speak. So what we're going to talk about today for you guys is what is required from TTB, which is the Federal Tax and Trade Bureau, the California ABC, Alcoholic Beverage Control, California Department of Tax and Fee Administration, Cal Recycles, and then if you do need something from the Secretary of State or Employment Law, those are minimal and will only really be an issue if you have an employee in the state of California. So I did leave those up here just in case that did apply to someone. So I was trying to figure out the best way to approach this and kind of meet everyone's educational needs. So what I did was I put together kind of a roadmap for each type of brand owner. And then I'll go through each agency and all the things that apply to one view. So for example, if you have a wholesaler license, there are certain things that will apply to you for CDTFA that won't apply to someone who has an importer license or won't apply to an out-of-state manufacturer. So what you'll be able to do is take your roadmap, and then whatever is specific to you is what you would want to pay attention to later in the presentation. And obviously I'll talk about things that won't necessarily be applicable to you, but you can then just ignore those. But I will also mention that with the having just an hour for this, I'm not going to be able to have, I won't have the time to go into how you do all these things, but what I've done is put together all the things that need to be done. And I've tried to include as much information on where you can get training, get resources, and get more information on how to do those things. And certainly that is also something that we do for a number of our clients. We offer a compliance package if that's something that would be of interest. But the idea of this is to make sure you all are aware of the things that need to be done and where to find that information to make sure those things get taken care of. So I have a roadmap for a brand owner who holds a wholesaler license, so a type 17 or 18. A brand owner who holds an importer license, which I know it says importer, just ignore that, the normal definition of importer, but that's an ABC type 10 or 13. And then if you're an out-of-state manufacturer whose products are being sold into California. So this will also apply. So for you California brand owners who may have an out-of-state manufacturer working with you, you might want to pay attention to both of these so you can make sure your manufacturer or co-packer is doing what they need to do. So let's jump into the roadmap for a type 17 or 18. So I did base this on the California license types. So you'll need a TTB basic permit. This is the most simplified license they offer. It's pretty much just information about your company, the owners of your company, and some of your background information. For California, you have a type 17, which is beer or wine, or a type 18, which is distilled spirits. This license does require you to have a warehouse of your own. I mean, when I say of your own, it can obviously be shared with other parties, but you need your own dedicated space where product will come to rest. Legally, it needs to come to that location and sit for 24 hours. With this license type, you can sell to retailers or to other distributors, but there is no direct to consumer privileges with this license type. This license type must price post. This license must file territory agreements that you have with your actual manufacturer with the ABC. And if, as a type 17, you are contract brewing or co-packing, you want to get your manufacturer to provide a primary American source letter. So rather than an out-of-state beer manufacturer or an out-of-state, sorry, manufacturer who's selling into California to sell their own product, this is literally you are contracting with someone specifically to create your brand. You hold a 17 or 18 to buy it from them. You want them to provide you with this letter because you'll need that going forward when you want to sell into other states. For CDTFA, the California Department of Tax and Fee Administration, with a 17 or 18, you're going to need a sales and use account because you have to file your non-taxable sales to that agency. You'll want a reseller certificate, and then you'll also potentially need, if you plan on transporting your product across state lines yourself, you will need an interstate alcoholic beverage transporter permit. Most people use a common carrier, but if you were going to transport it yourself, you would need this permit. Calorie Cycles, you'll need to set up a distributor account with them. And new this year, Calorie Cycles includes distilled spirits and wine, whereas they didn't before. And again, if you plan to have an employee in the state, you'll need to register your company to do business in California. So you'll need to register your entity as a foreign entity with the Secretary of State. Okay, so now let's say that you're a type 10 or 13 instead of a wholesaler. With this license, you still need a location for the license to sit, but you don't need to physically take possession of the product. So this is your true brand owner. This license type can only sell to distributors. There's no direct to consumers, and there's no selling directly to retailers. So you're literally just a true middleman. And this is the license that you need as a brand owner to be able to collect money from the sale of alcohol, even though you're not touching the product. It is also, the reason it's called an importer license, it is also the license type that someone who is receiving product into California to sell to California distributors would hold. Or a true wholesaler of multiple brands might hold this license additionally to theirs to bring product in from out of state and then distribute it within the state of California. That's why it's called an import license. This license also has to price post. You also have to file a territory agreement with the actual manufacturer, and you would also want to get a primary American source letter from your manufacturer if that's the situation. CDTFA, you're going to have an importer account. This will be actually required when you set up your, when you apply for your license with ABC, if you haven't already set it up, because you will pay excise tax on all product brought into California. And you're going to need detailed information on the transportation you're using. I'll also have examples of that later in the presentation, so you can see what kind of information they're looking for. You will also have a sales and use account. Again, you'll be filing non-taxable sales. You'll need a reseller certificate, basically showing that these are non-taxable sales. And then if necessary, you will need the interstate alcoholic beverage transporter permit. If you're type 10 or 13, Calorie Cycles is not applicable to you. So because you're not selling to you're not making the product, so you don't need a manufacturer account. And the way they define distributor is selling to retailers or consumers. And since you can't do either of those, you can only sell to other distributors, you would not need a Calorie Cycles account. And then again, same for you if you have an employee in the state, then you would need to register to do business in the state and get your company set up to handle the employee. And then last but not least, we have the out-of-state manufacturer. So this applies to both out-of-state manufacturers who are selling their own product into California to sell to retailers versus an out-of-state manufacturer who is a co-packer or a contract brewer for a brand owner in California. So an out-of-state manufacturer is going to need their manufacturing permit from TTB. They will also have to file formula approvals. They will have to file for the COLAs. And if they are doing a brand for someone else, they will have to register or file that brand name with TTB once they file for the DBA. Again, I'm going to go into more detail on all these things after. I just want you guys to have your lists first. For ABC, an out-of-state manufacturer needs a certificate of compliance. Part of that will require them to have an agent for service of process in the state. This is similar to when you register your company in a state and you need an agent. You can pay a company to be your agent. Most of them charge about $100 a year. You can use someone who is local in the state. I operate as agent for service of process for a number of people. I mean, it could just be someone in your business, but you want to make sure that whoever that is going to be reliable, because this is the person that if someone is suing you, that's where the paperwork will go, and you need to make sure it's also going to get to you. Also part of the certificate of compliance, you have shipping requirements. You have to use a common carrier, or you must obtain that interstate permit. You will need an out-of-state manufacturer certificate. 26 is beer, 28 is distilled spirits, and I believe it's the 27 is wine. I don't deal with this quite as often. You will also need to have a territory agreement with a California wholesaler or wholesaler importer to send product into the state. Now, the wholesaler importer is the one who has to file that with California ABC, but that is an agreement that's required. It does not have to be a full distribution agreement. It literally just needs to say that we're giving the rights to this wholesaler to sell our product in this territory. It can be very minimal. You will need a brand register. You will need to price post. Even if this is a contract brewing situation, you still need to set up those products in the price posting system, even if you're the one, even if it's not your brand. This is something it's not new, but because our price posting system is now online, it's becoming more enforceable. So make sure your contract brewer or co-packer is aware of that. For CDTFA, as an out-of-state manufacturer, you have to do monthly reports of all the product you shipped to a California importer. And again, and that's where you would get that beverage transporter permit if needed. For Calorie Cycles, you will have to have a manufacturing account with Calorie Cycles as a beverage manufacturer. You'll need to make sure you have label approval. Again, this doesn't have to be, it's not necessarily on your label. So most people who can, I don't know if you look at the top of your cans, but there's a lot of times a CRV information with a number of states listed. So sometimes it's going to just be on your can lid, not on your label. Again, new in this year, spirits and wine must register. And again, same notes for Secretary of State and employees. Okay, so now we're going to go into more specifics, and I'll be showing you some screenshots and basically helping you understand what all these things are and where to find them. So for TTV, so I'm not going into getting your licenses. That would be another whole hour presentation, just based on those licenses that you need on your roadmap. You'll need to file with those agencies to obtain those licenses before you start selling products. One thing you need to know for both TTV and ABC is keeping your information updated. So once you submit and get your basic permits, and this is a big thing because I've seen a lot of people make this mistake. You have to, if you get a new location, you need to file that with TTV. Now, if it's a whole new location, you're going to have to do a whole new application. But honestly, those applications are very short and they don't take very long to process. And there's no cost. So if you're planning to move your base operation, go ahead and get another basic permit at that new location, and then you can terminate the first one when that move is complete. But if there's no change of location, let's say you're just changing your mailing address, you want to keep that updated. Adding trade names, which we'll go into more detail on. And actually, I apologize, that's actually not on a basic permit. That is specific to the out-of-state manufacturers. So if you're packaging with someone else's name, you need to make sure those names are added to your TTV license and deleted when you're no longer doing that. A change of control. So new owners, new officers, new directors, new stockholders, change of your entity name. And then of course, if you plan on discontinuing your business, you need to file to discontinue the license. Formula approval. So when a product does not meet the base kind of standard for what, okay, it's probably easier for me to just explain this in terms of beer. And my examples will be beer today, mainly because that's what I deal with 90% of the time. However, a lot of these things are going to be either the same or very similar for the other beverages. But for example, beer is normally made from water, malt, yeast, and hops. So to some extent, if you're adding any ingredients that are not one of those four things, your beer may need formula approval. That said, in, I want to say 2015, the TTB put together a list of a number of ingredients that were accepted from formula approval. So if you add, and don't quote me on this, but I believe, okay, lemon, 99% sure lemon is fine. If you add lemon to your beer, you do not need formula approval. However, if it's not on that list, and I want, for some reason, I want to say lime is not on that list, you will need to get formula approval. This is normally caught when people turn in for label approval, and the label says that, you know, a lime IPA, then they're like, oh, it has lime, you need formula approval. However, keep in mind that no matter where this product is going, this is not a crossing state line situation. Since the FDA does not monitor your recipes and the liquid itself, the TTB does that for alcoholic beverages. So the reason they want to see formulas is to make sure there aren't things going into the food stream that are potentially unhealthy, or not unhealthy, but not good for human consumption. Let's just put it, that's probably the easiest way to say it. So there are also new beverages that always require formula approval because they don't meet any of the standard definitions. So if you are making seltzer, all seltzers need formula approval, and kombucha, all kombucha needs formula approval. There is no standard for those beverages at the moment. And again, this is whether it crosses state lines or not. And I will also say that when you get to the point where you do want to send something across state lines, many states are going to require copies of your formula approval. And only manufacturers have the ability to submit for formula approval. You have to have a manufacturing license with TTB to get access to formulas online. So you make sure your co-packer contract brewer is doing that for you if it is required, and you want to keep those on file somewhere because you will likely need them down the road. The same goes for a certificate of label approval, COLAs. Some states require you to have a COLA within that state. And I think that's just because they don't want to have their own label system. So they're like, oh, if the feds approved your label, we approve your label and you're good to go. California, for example, is not one of those. So if you are in California and you're only selling, and the product is made in California and it's only being sold within California, you don't need a COLA. However, you will need one down the road if you want to send it to another state. So again, if you're a California brand owner and your product is being manufactured, I would go ahead and have the manufacturer file for those COLAs so that you have them, so that you're good to go when you are ready to cross state lines. And if your product is being made out of state, you are required to have a COLA, because anytime you are shipping across state lines, you have to have a federally approved label. And that includes keg collars. Any labels. There is mandatory information, but there's also a list of allowable revisions. So if your label's already approved, but you have a minor change, certain minor changes are allowable without resubmitting. But again, this is something that if you're a brand owner and and you do not hold a manufacturing license, you do not have the ability to file for a COLA. So you have to get your manufacturer to do that for you. Again, they are the only ones who will have access. The only exception to that are importers that are importing from out of the country. But it's kind of outside today's topic. Okay, as a out-of-state manufacturer, if you need to amend, basically the way to add a trade name is you amend your application. So you would go into permits online And this is for a situation when you're packaging for a third party who wants their name on the product. So, there is a requirement brewed and canned by, brewed and kegged by, brewed and bottled by, and it puts generally the name of the actual manufacturer. If you are contract brewing or co-packing for someone and they want their name in that space, you can do that. You have to file a DBA or an FBN, doing business as fictitious business name, in your county of operation. And every county has its own process. Most of it requires filling out a state form that you send to your county recorder, and then many states, or many counties, I should say, still require you to publish it in a newspaper. But once you have that certified document, you can then go add that trade name to your TTB permit. And that way, when you file for a COLA, that label that has someone else's name on it, TTB will not reject that for having the wrong name on it. So that's the situation when, as a brand owner, you want your name, so that to the consumer, it's as if, they don't necessarily know that you had someone else make the product. Some people care about that, some don't. But that's what you need to do in that situation. And again, that's something that only a manufacturer can do. Just a little screenshot, if you're adding a trade name, it is an amendment. Literally, you click on the box amendment for trade name. And then it'll walk you through it. And there are tons of information, by the way, at TTB on how to do all these things. And actually, I apologize. I thought I had a link to that exact screen. But if you literally go to this training center, the Learning Center for TTB, and in that search, you were to type in adding a trade name, it would go to exactly the screen I showed you before. And it basically walks you step by step through how to do that. Okay, so I'm gonna pause for a moment to see. I realized I'm gonna stop this to see if there's any. Okay, nope, no chat questions. I just gotta double check between to make sure nobody has any questions, and then we will return. Okay, so on to ABC. Oh, there's my little box. Okay, that's why I'm gonna keep that at the top. So you need to have your ABC license. And this is, again, it's a very important, and I know I've heard so many people say, oh, you don't need an ABC license as a brand owner. But in the state of California, if you want to make money from the sale of alcohol, you have to have an alcohol license. That is legally how it works. So there are some workarounds, but again, you cannot base your you can't have a licensing agreement based on sales. If you want to work around the law, you need to make sure your licensing agreement, if you're licensing your brand to a manufacturer, is based on a flat fee, based on production, but it cannot be connected to sales. If you want to make money based on sales, you have to have your own license. The other issue, and that I think a lot of people don't think of down the road, if you don't have your own license, is then you don't really have control over your brand. You were licensing it to a manufacturer who then will be entering distribution agreements on your behalf because you don't have a license, so you can't actually enter a distribution agreement either. So keep that in mind. It's not a good position to be in. And I highly, highly recommend having your own license, which allows you to really control everything. With ABC, you need to keep ABC updated on any changes. Think of it this way: any information you gave them when you submitted on that license application, if any of that changes, they want to know about it. So that's pretty much the easiest way to think about that. And then you have to renew your license with ABC annually. TTB just continues until either you terminate it, or I guess, God forbid, you do something so egregious, they terminate it for you. But ABC will send you an annual renewal. If you don't receive it, you can still go on their website and renew your license, but just kind of keep that in the back of your head. They do send snail mail renewal information. ABC also requires brand registration, price posting, and territorial agreements. So let's, there we go. That was weird. Ah, now I went too far ahead. Okay, my buttons weren't working. Okay, so California brand registration. Every manufacturer of beer has to register their brand prior to first sale of that brand. There is a form ABC 412, that you fill out. It literally is name of beer, and this is beer specifically. Why it's beer and not spirits or wine, I don't know. Asking why when it comes to ABC regulations is kind of crazy. So it's the name of the beer, style of the beer, and ABV. You literally fill in this form, you sign it, you email it to that email address, and that's it. They don't respond. You should keep a copy, and then you can get that form on the ABC website. It's super basic, but I will also say that the way price posting is now, it is a bit duplicative, and you'll understand that in a minute. So price posting. Basically, everyone in California, other than a retailer, has to price post. So as you see that at the bottom, well, I'm sorry, let me take that back. Again, price posting is a beer only compliance item. So spirits and wine don't need to worry about this, beer only. But anyone who holds basically any type of beer license needs to do price posting. And this will include, so where you see where it says type 26, those out-of-state beer manufacturer and all holders of certificates of compliance. So if you're sending beer into the state, this is key, because this is where your co-packer, contract brewer, if they are out of state, they still have to basically get these licenses and input information into the price posting system. So how to file prices. So once you get your California ABC license, whatever type it is, you will get a notice, an email from ABC on how to register in that price posting system. All prices must be filed in the online system. And there's a lot of information how to do it. I will tell you right now, it is so much easier than it was when it was all on paper. It was very confusing, because one thing you should know, if you don't already, is you can, well, let me back up a minute for those of you who don't understand or not familiar with price posting. And this is very similar in a lot of states, but to keep an even playing field, you have to sell so if you're a manufacturer, you would have to sell to all retailers at the same price and to all distributors at the same price, which those two can be different, but you have to keep it fair and even. You can't have different prices for different distributors in the same area or different retailers that are in the same county. Same goes for wholesalers. And again, wholesalers are selling to wholesalers or retailers, and you have to have the same price for the same group of people within a county. Importers, you're only selling to distributors, but again, you have to sell to all distributors within a county at the same price. You can differentiate by county, but that's it. And the point is to keep a level playing field in the alcohol world. This is very, very surprising and difficult to understand by marketing people who come from outside alcohol. But for everyone in alcohol, it's pretty familiar. So what I will say, okay, so when to file prices, you have to file them prior to the first sale of beer, malt beverages to customers in California. And I'm actually going to take one step back before how to file prices, because the first thing that needs to happen is products have to get set up in the system. And that's literally like name of the brand, the actual manufacturer, trade name. So that's if you're the co-packer and you filed a trade name as the brand owner, that's what you would enter there. And then the name of the product. That is all that a co-packer or an out-of-state manufacturer, if this is a contract brewing situation or a co-packing situation, all they have to do is set up the products. 3 fields, super easy, super simple. If you are in a contract brewing co-packing situation, that manufacturer is not going to file, it's not going to price post, because this is a contract direct situation with you only. They only sell the product to you. So they don't need to price post. Price post is when selling to a group of retailers, a group of wholesalers. etc. So there's a lot of confusion around that. So how often to file prices? So if you're new, then you have to sell before you sell anything. You have to file before you sell anything. Once you're initially filed, you can amend your selling prices when you introduce new brands, new package configurations, new sizes, or any price change occurs. So prices are effective for the first time immediately upon filing, and amended pricing is 10 days later. There are situations where you can deal with a competing price. And I honestly, I haven't really done that often. So, but then you just need to note that in the system, that that's why it's being filed. Again, price posting could be its own, hour presentation. So I'm not going to go into too much more detail. You do have to have a territorial agreement on file with the state. So between the actual manufacturer of the beer and the wholesaler, excuse me, wholesaler is actually not allowed to sell any brand of beer unless they have a written agreement. Again, it doesn't have to be a full-blown distribution agreement, although that is highly recommended, but it should at least be a one-pager specifically saying what their territory is and that they have been approved by that manufacturer. Okay, CDTFA. This one is probably where we'll spend a little bit more time. Basically, every business in California has a CDTFA account. And if you have a license in California, you are also going to have one. So this is where the first thing you will want to do is create a login. So you're going to create a username and a password for yourself. And then you will register your business activity, whatever it happens to be. So these are the different things we're going to walk through. Everyone has to do the login, but I believe just about everyone needed a sales and use account, a reseller certificate, the transporter permit if you need it, an importer account. That's where it starts to get kind of tricky. And then the monthly reports of shipments to importers. So this is what and everything's online except for that monthly report. I don't know why, but so here's your sales and use tax return and what this is going to look like. This is just the first screen, which you give your total sales. And so for you guys, it's all going to be non-taxable. If you were in the state of California, because an out-of-state beer manufacturer, you can't sell direct to retailers in California. So everything you're selling in is non-taxable, and importers and wholesalers, you're all middle tier people as well. A California manufacturer, however, would have taxable and non-taxable sales theoretically. So that's what that screen looks like. The second screen will break down your non-taxable sales if there are any, kind of specialties. And then that's pretty much it. And the big thing is once you get your license, if you didn't sell anything, you need to file a zero report. And this is true of almost every state that is going to require sales reports. Is they want the reports even if it's zero. That way they know, it's been accounted for. Reseller certificate. The link at the bottom takes you to the actual certificate. This is literally a PDF that you will fill out. And so you will also need your seller's permit. When you set up that sales and use account, it's going to automatically create a seller's permit for you. And then this is where you fill in your seller's permit number. This is basically to prove to the California Department of Tax Administration that this was a non-taxable sale. You literally are supposed to have one of these for every vendor that you sell to that will then be reselling your product. I did not realize how much the CDTFA expects people to use these until just recently for the situation, but I do think you want at least one of these signed by every vendor you were selling product to that they are reselling. And that way you are covered when you report your non-taxable sales, that's how you prove that they were non-taxable. Again, if you need this permit, this is a CDTFA permit you would apply for via their website. Again, that's registering a new business activity. one of the questions is about being a common carrier or transporting alcohol, you click yes, and that's how you would get that permit. I've yet to have anyone who's done it that way. Most people use a common carrier. Okay, the importer return. And this is where, this one specifically is a beer and wine importer, but the distilled spirits importer return looks very similar. So you can upload your report as an Excel worksheet, but I wanted to show you the manual so you would see the information that you're going to need to give to them. Here's all the information you want. They want the name of the shipper's country, the shipper's state, the name of the common carrier, their account number. Now, keep in mind, you'll notice that some are required, some are not. So if you don't have your common carrier CDTFA account number, that's just fine. You need to let them know if it came via truck, rail car, or a ship. What was the bill of lading or freight bill number? Who did you buy it from? The invoice number, date received, and then they want the specifics of the actual product. Gallons. So know that you're going to need to have all this information for every shipment you receive into California, especially as a brand owner who is co-packing outside of the state. So, and then if you're an out-of-state beer manufacturer shipping beer into California, then you're going to file a report too. Yours is not online, and I believe it is due by the 10th of the month. There is a penalty for being late. It does say that they're all eligible to be paid online, but that's actually not accurate for this one. However, this screen is a link. That is the link to the beer shipments into California form, which is basically an Excel spreadsheet, as I'll show you in a minute. And anyone who needs, I will just request and I can send you a copy of the presentation so you can have the links as well. So this is the instructions for that out-of-state vendors reported beer shipments. So it's going to be a lot of the same information. Who's the importer you sent it to? What city did you send it to? And so this is the instructions basically for this lovely Excel spreadsheet. That's literally the form. And I will tell you, it's not very different in other states for out-of-state shipments. Most of them are PDF forms that you just fill in. So, and so I went ahead and so these are links to more information on the CDTFA website if you are dealing with beer, dealing with spirits, or dealing with wine. And this will basically all the potential alcohol tax things that you need to do with them. A lot of good information. And I think, yep, the CDTFA also has lots of tutorials, video tutorials, how to file these reports. They even have sales and use tax ones. So if you don't know how to do it, there's a lot of good free information on how to create those and to file them yourself. Okay, calorie cycles. So this is also, it gets a little confusing because calorie cycles uses the word manufacturer and distributor differently than your license type. So it's not like for like, unfortunately. So a calorie cycles, a manufacturer is anyone who bottles, cans, or fills beverage containers or imports filled beverage containers. And by imports that they mean from, well, actually, okay. Ignore that second line because I don't think that's as clear as it should be. So if you hold an importer license, you are not considered a beverage manufacturer. I do believe that they also might be referring to outside the country. So, but a manufacturer is a manufacturer. So if you're an out-of-state manufacturer, you have to create an out-of-state a beverage manufacturer account. You have to make sure that your labels or containers have the right information. And then if there are certain containers, so right now in California, if you manufacture and you put alcohol in bottles, for example, as a manufacturer putting alcohol in bottles, you will pay CRV to the state to Cal Recycles. However, right now, aluminum as a manufacturer, you don't pay CRV for that. However, that's where when manufacturers exercise their distribution privileges, and then a distributor is someone who imports beverages from outside the state for sale to dealers or consumers within the state. And by the way, when they say dealers, they mean retailers. They don't mean wholesalers. So this is where if you hold an importer license and you are buying from a California company and then selling, a California manufacturer, and then selling to a California distributor, you don't do anything with Cal Recycles because you're not putting it in the container and potentially owing money, and you're not selling the container to the end user and therefore potentially owing money. So it is a little confusing because the terminology sounds a little different, but it's not. And for example, California manufacturers have both a manufacturer account and a distributor account. So if they put it into bottles, they have to pay. Put it in the cans, that's not something manufacturers pay for right now. But if they distribute cans, they have to pay as a distributor. So it is a little complicated because the terminology is a little confusing because it is different than the way the licensing reads. And then new this year is wine and spirits are now also, and my guess as to why is because the amount of wine and spirits, now available in cans for one thing. So if you are and we don't have wineries or California wineries or DSPs on this call, but they will also need to register as both and then pay for what they're doing. Now, if you're a brand owner, as a type 17 or type 18 brand owner, you will register as a distributor, and any cans, because aluminum is the biggest one right now, that you sell to retailers, because you can't sell direct to consumer, but any that you sell to retailers, the on-premise, the off-premise, those you have to account for, and you will owe CRV to Cal Recycles for that product. Now, if you sell to another distributor and they sell, that other distributor is the one that pays. Their registration process, thank goodness you can now do it online. Used to be, it always had to be on paper. And then they will contact you, help you to determine which category you fall into, and then they will get you set up. Keep in mind, they do. So I had a client who did not know they needed to register, and they actually, the agent went back like on Instagram and was like, well, I see that you have a can from 2 years ago. So we basically had to go back and basically start them from that time period. They had done like a test run. So we filed, like 30 cans or some minimal number in that first month, and then like 12 months of zeros before they actually started producing on a regular basis. So they're very picky, and it is very important to them, but it is a very small amount of money, at least right now. So here's an example of what a craft beverage manufacturer report looks like. You put in your reporting year, first day of the month, last day of the month. If you have nothing to report, that's very easy. Just click that little box, and then you'll choose your style of container. So as a manufacturer, as it says here, there's no processing fee for aluminum. So you wouldn't even have to file. But if you're bottling, there is a processing fee for that, and the system will automatically calculate it for you. Here's a copy of a distributor report, and it's very similar. Reporting year, month and month, nothing to report. They have refillable glass containers back from the days of growlers, I suppose. And then of course your containers, and it is by size. So, and my example here is breweries that are doing those really large growlers. That would be their larger container versus anything else that's smaller. And this you are tracking by the number of containers versus, gallons or sales numbers. And then last but not least, if you have any employees in California, you'll have to review these items. They'll need a local business license, likely, if they have a home office. You'll have to register your company with the Secretary of State, which will trigger Franchise Tax Board, which that is now taxes for corporations and companies versus activities. And then you may need to file a fictitious business name, but again, that's normally filed in the county where your operations are. So where your manufacturing facility would be if you're doing that as a manufacturer. This is one thing I wanted to throw in because this is a new thing that applies to every company in the United States. It's federal, and they're looking for, basically, I think they're looking for hidden ownership. It's a fairly simple system. If your company existed prior to January 1 of this year, you have a whole year to file this thing. And then basically it's just trying to find hidden ownership. So check with your business attorney if you have further questions on that. I filed mine for my company. It's pretty straightforward. Minimum wage, just so you guys know, is now $16 an hour. That's the state. So you got to be careful because in California, we have localities that have their own minimum wage rates. Also, when there's a minimum wage on the state level, that adjusts the minimum salary. So if you have a salary, planning to have a salary employee in California, that is the minimum that they can make to be considered to be salaried versus hourly. I could also spend a whole nother hour on wage and hour issues and compliance in California, but that's for another day. And then this is the current list of localities with their own minimum wage ordinance. So based on where your California and generally a sales rep lives, this will determine what their minimum wage is. Minimum salary is always based on the state rate though. So this is only if they are being paid hourly. And that's it. I know I sped through that, but I did want to leave time for questions. Okay, so for the three of you, which is now two of you, who are both breweries. See if you guys have any questions. Happy to answer them. Happy to stay on. This will be available online later if you want to review it again. Plus, I'm happy to send you over the handouts. I'm going to stop the recording.